Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the Law Office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we're exploring what parents can do when somebody refuses to follow a court order, whether it's about parenting time, support, or property. Fedor, when you get that first call from somebody saying that their ex isn't following the court order, what kind of situation are they usually describing?
It's a great question. Usually it's all about money, sometimes violation of the parenting rights, such as visitation, can be other things, but usually it's about money. I'll quickly talk about the parenting time. I always tell my clients that parenting time is right, but it's not an obligation. And I usually compare it to your right to vote. So you have a right to go and vote, but you don't have to. So the same goes towards parenting time. Unfortunately, usually for fathers, they do not exercise their parenting time regularly. It's not a very good situation for the children because they're ready to go and see their father, and he has something else to do, and he simply doesn't exercise that right. But again, it's his right, but not an obligation, and he cannot be found in contempt for that. For non-payment of child support, for example, maintenance, things like that, everything that connects with the money, that's most of the calls that I get when someone is in default or not making payments for a considerable period of time. And that's when we have to file what's called petition for rule to show cause and bring it back to the court's attention.
Now, I'm going to ask you a question about that parenting time. That's very interesting about the right versus obligation. When parents are sharing custody, are you talking about sharing custody?
Well, there is no such thing as custody in Illinois for maybe even 10 years now. There is one. It used to be custody. We now call decision, allocation of major decision making. So people, parents make decisions on behalf of children in regards to healthcare, education, religion, extracurricular activities. Now, children have to live with a parent just for the purposes to enroll in school, doctor's visits, things like that, applying for medical insurance. So for that reason, we do establish who is a custodial parent for the purposes of living in one place. But again, even sometimes people have 50-50 visitation. So it's not really the father and the mother don't really have custody of a child because it's 50-50. Child support provisions would still apply, and we would still name one of the parents as a custodial parent for the purposes where the child resides, because the child has to have, like any human being has to have a residence. So for that purposes, we do establish who is the custodial parent for the purposes of the residence only.
So if a parent isn't exercising their parenting time, doesn't that put an extra burden on the other parent?
Oh, that's a huge burden. And that's what usually we have to deal with in the law firm. And that's what usually, from my experience, not all the time, but I would say 90%, this is the frustration that the mothers express to me, because, not only, again, everything we have to do, everything that the parents have to do, have to be in the best interest of the children. And when a father does not exercise parenting time regularly, or does not exercise the parenting time at all, that puts not only burden on the mother, but also it does not benefit the children at all. The other thing is that, life goes on, and a mother and the ex-wife, she has plans in her life as well, and she might need to change her schedule because the father decided not to appear. Now, there are some tools that can be established to protect mother's interest and children's interest, but it depends on the age of a child. So we're talking about children who preschool, uh, early ages, we can, the father could be responsible for the daycare expenses. If mother cannot stay with children, then he should be responsible for any daycare expenses, nannies, and stuff, things like that. With when children getting older, it's a little bit different. But again, the father can be responsible for after school and some other things that mom had to incur because the father decided not to show up.
Got it. Every order in family law is supposed to be enforceable, but what allows the court to make someone comply in practice?
Well, another good question. And then pretty much during any given consultations that I have with my clients, I always say that, I am a person that goes to court. And I live in this judicial system, and whatever happens in court sometimes completely different what happens in real life, and sometimes real life and the court life, two different things. And what I mean by that is that at the end of the day, what we get in court is a piece of paper that we call a court order, and that court order prescribes the parties, the mom, the father, certain rights, obligations, schedules, and things like that. Now, judges always say if parents decide to change the court order, modify it, or don't follow it, if it's by agreement, that's okay. You don't even have to go back to court. The court's there just to monitor, and in case of non-compliance, or when people cannot compromise, that's when the court sort of interferes and tells people what to do. But if the parties can find a compromise without court's intervention, that is welcome, because this is exactly what the system wants the parents to do, and the system wants the parents to behave in the best interest of children. So if there is a minor modification, and again, life happens, somebody got sick, somebody has a job interview, somebody has to go out of state, a simple phone call between the parents should suffice. Sometimes emotions take best of people, and sometimes there is no cooperation at all. So if that happens, as I said at the beginning of our conversation today, we file what's called petition for rule to show cause. The party that files this petition for rule to show cause has the burden to establish that the other party willfully, intentionally violated the court order. What I mean by, and it's very important, these terms, willfulness and intent, because if somebody gets in a car accident and ends up in a hospital, it's something that is not willful. And if someone loses her job because she was fired or laid off due to COVID, or whatever the reason could be, it's not willful or intentional violation. If someone decides to be not employed or quits the job or doesn't pay the child support or whatever financial obligations he has to pay, that is usually a willful violation of the court's order. And that's what the petitioner has to establish, the willfulness of this violation.
Can you walk us through how a contempt motion works and what the court can do once it does find somebody in violation?
Of course. So once a petition for contempt is filed and the burden by the petitioner is met, and usually it's very easy burden to prove. It's by preponderance of the evidence, and all the petitioner has to show is that she did not receive certain payments or the respondent did not follow the court order. Then the burden shifts towards the respondent, and now respondent has to prove that whatever he didn't do was not willful or intentional, and there is a good explanation to his actions. And if he fails to do so, the court will have the violator in contempt of court. Again, we're talking about civil court. It's not a criminal court. So
Right.
to put somebody in contempt of court and jail, it takes some time in civil courts. But there's going to be an order of contempt. Order of contempt means two things. First, the respondent has to comply with the court order, and so-called purge will be set usually 30 days out depending on the violation, but usually 30 days out for the respondent to comply with court orders. And then the respondent would have to also pay any attorney's fees for the petitioner for enforcing the court order. If the respondent does not cure the violation, he can be held in contempt of the court. That means that he's going to go to jail in a county where the courthouse is. And being on both sides of the spectrum, sometimes I hear from violators of the court orders that, so what? I'm going to be in contempt of the court, and they're going to release me at any point anyways, which is true. But there's not going to be any bond set for the violation. There's going to be a bond set for the violation of the contempt. And usually if we talk about the money, the amount of the bond is going to be exactly the same amount as the violator failed to pay, which is different from criminal court that used to be, I don't think we have in Illinois anymore monetary bonds, but it used to be that it was only a percentage from the bond that you have to pay in order to be released. So in civil courts, you have to pay the full amount. If you pay the full amount, whatever it is, it's $50,000, $10,000, $1,000, somebody from the outside has to pay it in order for the violator to be released from jail. And once he is released, he is back in front of the judge, and he has to continue comply with the previous court orders.
In your experience, how does a judge decide when to penalize versus when to give someone a chance to fix the problem?
Judges very strict about child support. So with child support, usually there is no room for violation. And of course, if there's a good explanation why the payment was missed, and if a payment was missed for 1 month, maybe the judge, again, acting in the best interest of the children, would instruct the respondent to pay it instead of taking the respondent into custody. And once the respondent is custody, he's not working anymore, and likely that the child supports are not going to be paid for additional months going forward. So judge would consider that. But if we have multiple violations, or if these violations keep occurring, and that's another frustration that sometimes I hear from clients. And again, I would say usually mothers, when the fathers would not pay child support, it's a vicious circle. Essentially, a father would miss 3-4 months of child support. The mother has to file a petition for rule to show cause. It'll take time, 2-3 months, until the judge finally rules on petition for rule to show cause. The father, husband, pays the child support, and then he stops paying again. And that means that the mother has to file a petition for rule to show cause again. And sometimes it's very exhausting. But again, the payments for child support, judges across the state of Illinois and counties where I practice, they view it very strict compliance. You have to pay child support by all means. Maintenance, child-related expenses, other things like that. Usually you have to, especially for the expenses, you have to give the other side the proof of payment notice, and the other side can repay it within a certain period of time. But child support is a big no-no.
Have you ever handled a case where strict enforcement actually backfired, maybe making co-parenting worse, and you had to find another solution?
That is a very good insight. Of course, if a strict enforcement is actually enforced, for lack of a better word, yes, the whole change in the visitation and parenting time can be potentially shifted. And then, the children would miss certain parenting time with the parent, not being able to see a biological father or mother for a certain period of time. Would it change the whole entire parenting schedule going forward? It's hard to say. It depends on the time when the person would spend in jail. Usually, from my experience and what the judges say all the time, everyone is tough and brave before they put in handcuffs, and as soon as person is in handcuffs and is in jail, they usually find the way to post bond within a day or so. So to answer your question, I cannot come up with any examples where it would really backfire. I think it makes the process more strict, and it shows to the violator that future compliance is a must.
I think sometimes people also think, I'll just handle it myself. Well, what risks do they take by trying to enforce an order without going through the court?
Trying to enforce the order without going to court? I don't think it's a good idea. I think the court system has a very good tools as far as the enforcement of certain court orders. And again, I'm not only talking about money, I'm also talking about parenting time and other things. But again, when you can sort of represent yourself if you go to court and try and enforce the court order. If non-payment of child support is a non-payment of child support, you just have to prove it. On the other side, if I ever have a client that comes to me and say, hey, I've been back on my child support for X amount of months, can you defend me? And usually by saying, can you defend me, they mean, can you modify my child support? And I usually say that it's better to pay or settle with the other side. One very important thing here is to remember that you can modify child support only by filing a motion to modify. Sometimes people make this huge mistake. If you don't make that much money anymore, and if you lose your job, if you didn't file a petition to modify child support, this child support obligation doesn't go anywhere. Retroactively, you cannot modify child support. You can only modify it going forward.
Well, just briefly, as we wrap up here today, for anyone listening who's stuck dealing with a non-compliant ex, what's the best first move to protect themselves and get results?
First of all, you need to document everything. So whatever we're talking about, if the other parent does not exercise parenting time, get a calendar and mark the days when he didn't show up. If he doesn't pay support, one of the best ways to do it, first of all, take a calculator and calculate everything and write it down. And secondly, send him a message and say, hey, you missed the support. So in the future, when you go to court, you can present it to the judge, not only the amounts that he's missing, but also your attempts trying to resolve it out of court. Judges always appreciate it.
Well, that's it for today's episode of the Family Law Frontline. If you're facing a situation where a parenting or support order isn't being followed, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for tuning in, and remember to leave a review, and subscribe to the show so you catch every episode. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.